Now we're reviewing the case of Estate of Nelson versus Rice. That's at 198 Arizona, 563. It's a year 2000 case in the Arizona Court of Appeals. The problem was a person or couple passed away, had an estate, and the estate sold a lot of their artifacts, stuff left after they passed. It was Martha Nelson died in 1996, and Newman and Franz, the co-personal representatives of her estate in the probate proceeding, they employed Judith Mackenzie Larson as their appraiser to appraise the estate's personal property. They knew that there was a collection of Indian art that might have been worth more than they knew, so they hired a specialized Indian art appraiser to appraise that. As to the other art hanging on the walls in frames, they told Judith Mackenzie Larson, "Would you appraise that too, the art?" And she said, "No, I'm not any good at that. That's not my specialty. You'll need somebody else to do that." "Well, just let us know if you see any of that precious art, high-value art." Right. So she went about appraising everything, and then they had the sale. She didn't appraise paintings. And then Carl Rice showed up at the sale, and he bought 2 paintings for $60. So he later noticed that they appeared to be similar to the paintings of an artist whose work he had seen before, named Martin Johnson Heade, Heade. So he authenticated the paintings by, first he saw that they were signed, appeared to be, by Heade, and then he sold them to Christie's. And Christie's is a New York auction house that auctions some high-end stuff. Well, this turned out to be high-end. The painting sold at auction for over $1 million. Once they subtracted the auctioneer's commission, it was a little over $900,000 net to the bank account of Carl Rice. Well, Newman and Franz, the executors or administrators of the estate, learned about that sale and wanted it overturned. They sued the Rices, alleging mutual mistake. They want the contract rescinded. They want the contract reformed. Reformation means that the court will go in, reform the contract, and put the appropriate price on the article. Didn't work here because the Rices argued that the estate bore the risk of mistake. And that's why the court denied the estate's motion for summary judgment and granted the Rices' cross motion to dismiss the action or summary judgment, which resulted in a dismissal. So the question that this court faced was this correct? That is to say, was this a case of mutual mistake or not? Well, they started with the law. A contract may be rescinded on the ground of a mutual mistake as to a basic assumption on which both parties made the contract. Of course, the Rices opposed that, but the estate of Nelson said the basic assumption we both had was that these were cheap knockoffs. They weren't the real thing. The trial court found that although a mistake had been made as to the value of the paintings, the mistake fell onto the shoulders, let's say, of the estate. Here's why. They turned to 154B of the restatement and the trial court and looked at section 154B comment C. The authors of the restatement include comments that explain the restatement section, if you will. And restatement section 154B comment A tells us that a party bears the risk of mistake when he is aware at the time the contract is made that he has only limited knowledge with respect to the facts to which the mistake relates, but treats his limited knowledge as sufficient. The Washington State Supreme Court referred to that as conscious ignorance of the future and said that's not a mistake where there's an aware of uncertainty or conscious ignorance of the future. That's not a mistake. Well, conscious ignorance has been defined by comment C as follows, and I'll read this to you. Conscious ignorance. Even though the mistaken party did not agree to bear the risk, he may have been aware when he made the contract that his knowledge with respect to the facts to which the mistake relates was limited. If he was not only so aware of this knowledge, but was limited, he was not only aware that his knowledge was so limited, but undertook to perform in the face of that awareness, he bears the risk of mistake. It is sometimes said in such a situation that, in a sense, there was not a mistake, but conscious ignorance, period. So then we look at Mackenzie Larson. She specifically told Newman that the state representative that she didn't appraise fine art. And then she was silent as to the painting, of course, because she didn't appraise fine art. But he believed that the estate contained nothing of value except the house and the Indian art, because he relied on Mackenzie to notify them of any fine art or whether a fine art appraiser was needed. Well, she didn't say they needed an additional appraiser, and she didn't say there was any fine art. She just didn't say anything. By relying on the opinion, by silence that is, of someone who was admittedly unqualified to appraise fine art to determine its existence, they consciously ignored the possibility that the estate's assets might include fine art. Therefore, they assumed the risk. Well, the estate brings up a case involving commercially grown jojoba. That's their Renner case. Let's see what that is. The Renner case is at 150 Arizona at page 97. Jojoba, by the way, is a goat nut, or a pig nut, or a deer nut, or wild hazel, or coffee berry. It's a nut which produces jojoba oil, which is used in cosmetics. In that case, the buyers wanted to rescind because they bought land from the seller in order to grow commercially jojoba. And after they bought it, they discovered the water supply was inadequate. So the buyers, the Supreme Court said, could rescind the contract based upon mutual mistake because both the buyers and the sellers had believed there was an adequate water supply, a basic assumption underlying the contract. Well, understandably, the estate's representatives relied on that case, but the state's reliance on renter is unavailing because the estate bore the risk of mistake based on its own conscious ignorance. In the renter case, both parties were mistaken, but not based upon their own conscious ignorance. Here the estate had ample opportunity to discover what it was selling and failed to do so. Instead, it ignored the possibility that any of the paintings were valuable and attempted to take action only after learning of their worth as a result of the efforts of the Rices, who, you could say, quite correctly, they had the paintings appraised. The estate was, this court says, a victim of its own folly, and it was reasonable for the court to allocate to it the burden of its mistake, and they affirmed then the trial court's determination. So you have to make a mistake. Don't make a mistake. You have to make a distinction between cases in which there is unawareness of uncertainty or conscious ignorance of something, and a case where there is a risk of mistake that is not allocated to one side or the other, but is basically shared by both because neither party knows of the true fact. And that situation, that neither party knows of the true fact, does not occur because one of the parties relies on his own conscious ignorance.